So that being said, I'm going to turn over the reins, if you will, to Attorney Jonathan Ellis. Mr. Ellis, again, welcome. We truly appreciate your time. And literally, I'm going to hand it to you, and you can take it away, my friend.
Hey, Paul, thank you. And not only thank you and thank Associa for turning it over, but for all that you guys do for the world of community associations within Florida. The presentation should take about 2.5 hours without questions. But if you have questions, just please forward them. Most of you, I don't think, know who I am. I will tell you that I am a board certified community association attorney. I've been doing this since about 1990. So I wound up graduating law school at Vanderbilt and moving down to Florida back in 1990. And in 1992, my wife and I wound up buying our first house, and it was in a deed restricted community. It was 1,800 homes, 2 apartment complexes, and an assisted living facility. And I wound up looking at this, thinking to myself, who are these people that can tell me what I can or can't do with my house? And I wound up reading the declarations and trying to make a determination, is this really a place that I want to live or not? And as I read through them, I reached the conclusion that, while I didn't like the idea that anybody could tell me what I could do with my property, I certainly didn't have any objection to any of the declarations themselves. And I wound up getting on the ACC, which was the Architectural Control Committee. And from there, I wound up on the board of directors. And from there, I was president for a number of years. And as I was on the board, our council, meaning the council of the association that I was in, wound up asking me if I could help them with a case in which they were, in which another association, which he was representing, was involved. I was a litigator in Florida. I said, this is what I do. Sure. And he said, you need to have a conversation with this woman in New York City before I can authorize you to handle this case. And it was an interesting case because it was dealing with another association that allowed somebody to build a fence. And the neighbor of the guy that was allowed to build the fence got upset and wound up suing the association and every other board and every board member individually and the neighbor who built the fence. And we handled that case. We wound up getting it resolved. And sure enough, about 3 weeks later or 4 weeks later, I got a call from this same woman asking me to handle another matter. We handled that. And then she asked me if I would, if I would mind handling matters that were arising throughout the state. She wound up was managing a insurance portfolio. It was a not-for-profit book. And as a result, I found myself for a number of years representing various not-for-profits, which meant about 80% of the claims were all were condominium associations, homeowners associations, mobile home parks, timeshares, co-ops that wound up getting sued or had claims against them. And we handled those for a number of years. And as I was doing that, and as we were representing the associations, I wound up getting or receiving calls from the various associations that we were handling under their policies saying, look, John, you're doing a good job for us. I have a question. Our current counsel's not getting back to us. Could you help me with this question? Or we're getting advice from our lawyer. This doesn't sound right. Could you take a peek at it? We would look at it, and 80% of the time or more, the lawyer would be right. But every once in a while, we'd say, ask the lawyer about this case or this statute, or why you wouldn't do this way, or why some questions about the advice. And from that, I wound up representing associations that were being sued to growing a practice now at Shoemaker that consists of a total of 7 lawyers. 2 lawyers do full-time collection work and what I call covenant enforcement or violation work. Another 4 lawyers strictly do general counsel work, you name it. Questions on can we close a board meeting, to land use questions, to questions regarding can we charge interest or at what rate or how do we do it? Can we amend our declarations? What happens when the president's not following the direction of the board of directors? How do you do a recall? anything that you can think of. Does this violate, how do we handle an emotional support animal? Does this violate a HUD requirement? And so we now do that full time, and we've been doing it for a number of years. Every time when I think that I've seen it all, I got to tell you, we get a question that we have never seen or that we have to figure out. Shoemaker has about 270 lawyers in it, about 110 lawyers within the Tampa Bay area. But I've made sure over the years that anybody who uses us will not get lost in a big firm. I always say, if you're happy with your counsel, stay with whom you have. If you are not happy with your counsel, please consider us if you're thinking of making a switch. As Paul said, this is the board certification class. So I always like to say to each of you, congratulations for being on the board of directors. Everybody always says, John, do you mean congratulations or do you really mean condolences? I actually mean congratulations, because it means that the members of your community or the board of directors that appointed you have enough faith in you that they are willing to use, use your judgment to make some of the decisions that you may be making on various unit owners' largest investment, which is their condominium or their home. Looking at who signed up, we're about split 50-50 between condos and HOAs. I think a little more on the HOA side, but we will be covering both in this in this board certification. So, and I'm looking to see if I can switch this. Give me 1 second. So what will we cover? We'll cover operating your condo or HOA, bids and contracts, official records, maintenance and access, budgets and reserves, and elections. It starts off slow and we pick up speed as we go. So operating a condo or an HOA, there's a fundamental duties that each board member needs to do. Number one, you need to actually establish a budget. You have to levy the assessments in order to pay for those items that you have in your budget. You have to direct the management company, the attorneys, and the collection process, and any other agents or employees that you may have. You have governing documents. Believe it or not, you actually are obligated to enforce those governing documents. I always say the governing documents are the governing documents. So your job as a board member is not to pick the terms that you want to enforce and just decide nobody wants the next 1/3 enforced. So let me just take a black magic marker and draw through that 1/3, and then have a new board come in and decide they also don't want to enforce a 1/3 or a 1/4, and then pick a different section that they're not going to enforce and start enforcing what you were not enforcing. You have an obligation to enforce the governing documents. If you don't like what's in there, just amend it. People move in on the basis that you're actually going to enforce what those governing documents are. And probably one of the most important things you actually have to do is maintain the common elements and the common areas. So what governs a community association? And by the way, if you have questions or comments, please use the chat function and I will monitor it and try to pick up the questions as they come. So what governs an association? The first thing that you have are the declarations. The declarations are the documents that actually attach to the dirt. Before any unit is ever sold, before any house is ever sold, the developer will record the declarations, and that attaches to the dirt. And that's what allows an association to do a couple of things. One, it tells you what you can or can't do with the property. It tells you if you're going to be in a condominium or homeowners association. It's going to tell you that you're going to be the member of an association. It's going to tell you what you can and can't do with your property with respect to commercial vehicles, with respect to garbage cans, with respect to building above ground pools. It's going to tell you that if you live in this property, you are going to have to pay assessments. And if you don't pay your assessments, the association has the ability potentially to foreclose on your unit, and that you're waiving your homestead rights with respect to the association's lien obligations when you move into this community. The declaration you can spot. So if you've looked at your governing documents, the declaration usually says in an HOA, the declaration of covenants, conditions, and restrictions, or in a condominium, it generally says, the declarations, covenants, conditions, and restrictions for such and such condominium, and it usually has the name of the condominium in it. You'll look at it and you will see an OR book and page number on top. The OR stands for official records, and that's the county, and then that document is recorded in the county in which your association is located. Then there's a BK, that stands for book. Then it has a number. And then there's a PG, that stands for page. That has a number. In the old days, you used to go down to the county courthouse, into the clerk's office, and you could find a document by asking for the right book and the right page. And then they would pull out that book and you could open it up to that page. Now, if you look at it, you can do most of this online with any clerk's office. But if it says OR book 4157, that means 4,517 is the book, and the page number is 816. That's the page number where it would be recorded. By recording the document in the public records, it puts the entire world on notice that there are declarations to which the property is subject. So the way this normally works is when you buy a piece of property, you get title insurance. Or if you don't have title insurance, normally somebody should be looking at this. And what they do is they look at from whom you bought the property, and they go forward and they make sure, did that person put a mortgage on it? Is there a lien on it? Is there a judgment on it? Is there easements on it, or things like that? And what they normally do is they go back about 30 to 40 years and they trace it from whom that person bought it, from whom that person bought it, from whom that person bought it, from whom that person bought it. And then they trace it up to see what may have been added with that person's name to the property after it was, after that the first person bought it. Normally, as you trace that back, you'll go from whom you purchased it from, who they purchased it from whom they purchased it, and then you're going to bang into the developer. And then when you trace it up, you'll find out that at some point the developer actually recorded the declarations, and that puts the world on notice that the declarations are out there. Now, not everybody actually does that on an individual basis, but every title company does it. And if you look at your title policy, you will see that it is subject to the, to various recordings of record, which would include the declaration. So that's what the declaration is. That's the paramount document. You also have the Articles of Incorporation. The Articles of Incorporation is the document that actually creates the corporation. So corporations just don't automatically appear, but rather they have to be created. And how you create those is you wind up creating an Article of Incorporation, and you file that with the Secretary of State. If you go on to sunbiz.org and you type in the name of your corporation or association, the full name, the Articles of Incorporation as well as the annual report should be there. The Articles of Incorporation generally tell you how you run the corporation, or what the powers of the corporation is, such as you have the ability to borrow money, you have the ability to file suit, you have the ability to enter contracts, you have the ability to lease property, you have the ability to borrow money, you have the ability to create rules and regulations. And the articles generally create it. They tell you what the powers of your association are, and they also tell you who the initial board of directors are, as well as who your registered agent is. The registered agent is the person or entity that is authorized to accept documents officially on behalf of the association. The bylaws are the next document. What do the bylaws tell you? They, in essence, tell you how you run the corporation, such as for a membership meeting, what is a quorum? What type of votes do you need at a membership meeting? Do you need a supermajority or do you need a regular majority? Supermajority meaning 2/3 or 3/4 or something like that. Tells you for the board of directors, how many members of the board of directors are there if it's not contained within the bylaws? How are the directors elected? How are the officers elected? Potentially, what are the duties and responsibilities of each of the officers? It'll tell you potentially what committees you have to have, when the annual meeting should be, how the annual meeting is conducted. Sometimes it'll have an agenda, but it generally tells you how to run the corporation that was created by the Articles of Incorporation. And then you have rules and regs. Rules and regs are not generally can be adopted by a board of directors. Generally, if you're going to amend the declarations, the articles of the bylaws, for the most part, that has to be done by the membership. The board of directors can actually adopt, for the most part, rules and regs. But the rules and regs, if you're adopting them, generally cannot create restrictions that don't already exist. Typical rules and regulations are things such as the pool is open from sunrise to sunset or from dawn to dusk. if you have issues relating to leasing, a lot of times the declaration will say that there are restrictions on releasing pursuant to the rules and regulations adopted by the board, and then the board adopts rules and regulations. Sometimes you can't park commercial vehicles, and the board will adopt rules and regulations that constitute commercial vehicles. You can't use the rules to create general restrictions on their own that don't have some authority that is already within the declarations, the articles, or the bylaws. We do this a lot. We do it all day long, and occasionally, believe it or not, we find provisions of the declarations, the articles, the bylaws, or the rules that may conflict with other aspects of the same. And when they conflict, you got to figure out which one controls. Generally, the declaration trumps the articles trump the bylaws trump the rules and regulations, hence why we have them in the order in which we have them. You're also governed by Florida law. Chapter 617 is the statute that governs not-for-profit associations. What is a not-for-profit association? A not-for-profit corporation. A not-for-profit corporation is a corporation whose function is not to derive a profit. So if you were to turn around and you were to look at the NASDAQ or the Dow or the S&P, those are for-profit companies. Their goal is to earn money and distribute the proceeds to shareholders, with the exception of Apple, that never makes a distribution but continues to enhance its book value. But the general rule is, under 617, your goal is to function the way you need to function. You want to have enough money to carry out your duties and responsibilities. You don't make distributions to the owners, but you do have the money and the protection of a corporation. And then when you take in the money, you use it to maintain what you need to use it for. You're not looking to earn money off of unit owners. You're looking just to maintain and have enough money to do what you need to do. And part of having enough money means having enough money. You don't want to create assessments that are so low that you don't have the ability to do what you need to do when you need to do it, such as repairs to a pump that goes down, the fact that you may be involved in a lawsuit or some other problem comes by. But your goal is not to stockpile money so you have more money than you will ever need. Chapter 718 governs condominiums. Chapter 720 governs homeowners associations. If to the extent there's a conflict between 617 and 718 or 720, generally 718 and 720 will control as being more specific over 617. Condominiums are also governed by the Florida Administrative Code, and then you have case law. You live in a common law state and you live in a common law country. What does that mean? That means that people get in disputes, and when they get in disputes, they go to courts. And when they go to the courts, they wind up bringing in a decision, and courts make bringing in disputes. Courts make decisions, and when people that are in front of the court, or entities such as an association is in front of a court, and they don't like it, they appeal it to a higher court, such as a district court of appeals in Florida. Most of you are within the 2nd District Court of Appeal, to the extent you are in one of the counties that comprise Tampa Bay, or all the way down, I think, to Fort Myers or to Naples. So you would go to the 2nd District Court of Appeal, you'd go to the 11th Circuit Court of Appeal if you're in the federal courts, or you would wind up with either the state or federal Supreme Court. When the Court of Appeals make decisions, they write down the decisions, and then those decisions provide guidance, and they actually become binding in the jurisdiction in which the decision was written. So what does that mean? It sounds complex, but there are certain things that you wind up needing decisions on. So the example I like to give is that an association has a rule that you can't have signs on your car. And so somebody parks their car within an association, and they have a sign in the window of the car indicating, what business they work for or something like that. Association indicates, look, we've got a rule. The rule says you can't have a sign on a car. The unit owner says, no way. Your rule says it can't be on a car. If you look at my sign, it's in the car. It's not on the car. It's in the window. Association says, no, in, on, it means the same thing. They wind up going to a trial, a judge winds up making a decision. One of the individuals is necessarily unhappy with the decision, and they appeal it to one of the appellate courts. The appellate court looks at it, and it makes a decision. And the appellate court says, in means in, on means on. So if you have it on the car, that's prohibited. If you have it in the car, that is allowed. And your restriction that says on a car doesn't prohibit somebody from placing a sign in a car, even if it can be seen outside. As a result, within the state of Florida now, everybody knows on means on, in means in. So if you're having a similar issue with your association, that gives you an idea, heads up. The court's already decided that. You know, it's just, you need to use that as a level of precedence. That's how common law works. And as you look in law libraries years ago, law firms would have these massive libraries. Everything's online now, but you would have to go through the cases. Occasionally you have issues where the statutes or the case law will conflict with your declaration, your articles, or any of your governing documents. And that time you need to get an analysis which one controls. That is not a simple question. That can get awfully difficult. And usually if you're trying to determine whether whether a law that is enacted is retroactive, meaning it changes what you have in your declaration, we normally recommend you obtain a decision or an opinion from counsel to advise. There are certain times that the law will take precedence over a deck. Other times, courts will determine that just because the legislature creates a new law, it doesn't necessarily affect a declaration which these people had moved into prior to the law being created, and therefore the law is not necessarily retroactive, and there's an analysis that's done. There's also the DBPR, which stands for the Division of Business and Professional Responsibility. That generally has a governing aspect over condominiums, timeshares, mobile home parks. It generally does not have authority over HOAs, barring an election dispute, of which the DBPR decides for associations. So when you ask your lawyer, you have a question, what is the law on this? Good lawyers will look at the decks, the articles, the bylaws, the rules and regs, the statutes, the administrative code, the case law, and that's why this gets at some level to potentially be tricky and then be able to provide you your answer. Most lawyers who practice in this area already have a good handle on what most of this is, but you have to still look at it. Every time I think I know what the answer is, by the time I pull out the deck, I look at it, I can't tell you the number of times there's something that seems to be an opposite or different with a specific deck or a specific bylaw. So I always tell anybody working for me, before you start shooting off your mouth, make sure you actually tell people, make sure you actually look at the governing documents. These can be tricky. They can be tricky in providing an appropriate answer. You also have a fiduciary relationship with your association. That means you have to promote the interest of the association above your personal interest. You actually have to discharge your duties in good faith. So if your sole purpose to get on the board was to take vengeance against your neighbor, when that vote comes up, think about what is in the best interest of the association, not in your own personal best interest. It doesn't mean the votes you don't take can't be in your personal interest, because most of the time your personal interest will be the same as the association's interest. But occasionally it's not. And when it's not, you need to be aware of it, and you need to abstain or back out of such decision, or vote what you believe to be in the best interest of the association. Some of these are classic examples. For instance, you wind up having your daughter owns a landscape company, and you want to try to get your daughter's company to get a job with the association as the landscaper. That's the obvious one where you may have a conflict of interest, or there is a question of whether you're discharging your duty in good faith. Or if somebody attempts to bribe you to turn around and use their services or not take a specific action. But there are times that you may find your unit is a different situation than all the other units in the association. You're there to make the best decision on behalf of the whole association, not just your unit. And as a result, when you're voting, you need to be voting where you think to be is the best interest of the association. Because the board member sitting next to you isn't voting the same way you are, and because you are fulfilling your obligation to vote in the best interest of the association, it doesn't mean the board member who's not agreeing with you is breaching their fiduciary duty. They just may believe that what you think is in the best interest of the association, they don't think is in the best interest of the association. You need to accept that and move on. The association actually owes to the unit owners to use the care an ordinary prudent person in a like position would exercise under similar circumstances in a manner they reasonably believe to be in the best interest of the association. That's a mouthful. What does that mean? That means when you're sitting at the board table, you're not a lawyer, you're not an electrician, you're not a landscaper, you're not an irrigation specialist, unless of course you are, you're not a licensed community association manager. You're expected to bring the general skill that an ordinary prudent person would bring. So let me give you a couple of things that ordinary prudent people do and a couple of things they don't do. Ordinary prudent people, when somebody tells them there is a lip in the sidewalk and somebody could trip on it, ordinary prudent people don't do nothing. Ordinary prudent people actually look at it, try to make a determination if it prevents a danger, and take the necessary corrective actions. Same thing when an electrician tells you there's an open wire, be careful. Or if you're in a high-rise condo that the balcony railing is loose, can you look at it? You need to look at those. Life safety issues are paramount. What do ordinary prudent people not do? Get an email telling you there's a lip in the sidewalk, send an email to the rest of the board saying, this is going to be a $500 fix. We don't have the money in the budget this year, but we actually need to address it first thing next year. And then when somebody actually 2 months later walks by the sidewalk and trips, puts their arm out to block their fall, breaks their arm and cracks their eye socket, you're trying to explain to a jury why you believed it wasn't prudent to go ahead and fix the sidewalk right away. So when you're dealing with life safety issues, you need to take those actions that you need to take to ensure that people are safe and that property is safe. Rarely is a officer or director of an property of an association individually liable. Where are the areas that you can be liable? You can be liable in the following areas. Number one, if you commit a criminal act in the capacity as an officer or director, don't hit people. Don't vandalize property. Don't embezzle money. If you commit a crime, you're personally liable. If you deal with gross negligence, so that means that not only aren't you doing what an ordinary prudent person would do, but you're dealing with wanton and willful negligence. What is gross negligence? The example that you're always taught in law school is somebody winds up firing a gun into what they think is an empty house, and they wind up hitting somebody. That is just wanton and willful. And as a result, if you're dealing with gross negligence, you could have personal liability. And three, if you wind up enriching yourself or wind up getting some level of consideration back or substantial benefit other than what the rest of the community receives, you have a potential of being personally liable. So who considers whether you're using the ordinary care or the care an ordinary prudent person would use? Who makes that decision? That decision is usually made by a judge, or a lot of times it's made by a jury. Who's on your jury? Next time you're in Walmart, look at who's in front of you in line. Look at who's behind you in line. That generally is who comprises the juries in this area. You're not getting a sophisticated jury. These are the people that are going to be determining whether you used ordinarily, the care of an ordinarily prudent person. You as a member of an association have a duty of confidentiality. That means that there are certain things you're going to receive information on, and you are not allowed to disclose it to everybody. It includes personnel records if you have employees, requests for accommodations for handicap. So a lot of times people want emotional support animals, regardless of whether you believe what's in the application or not. The fact that somebody tells you they have PSTD because they wound up serving in Iraq or Afghanistan or molested as a child, you're not allowed to go tell your spouse, your neighbor, your children, that, hey, let me tell you why this person gets a dog that's larger than we allow, or an extra animal. That information is confidential regardless of whether you think it's true or not. To the extent you receive personal identifying information of owners, social security numbers, bank account information, driver's license numbers, all of that is confidential. If you require people to submit sale or lease applications, confidential. You don't disclose it and you don't tell people what's in there. Attorney-client privilege information. You live in the United States and you live in the state of Florida and you have a right to counsel. In order to communicate with counsel, you have to be able to communicate in a manner that the person you're about to sue or is suing you doesn't get to sit and listen in or ask you what your lawyer told you. You will get letters from lawyers. They should say attorney-client privilege on it, but if not, they still are attorney-client privilege if it's a communication between you and your lawyer. You do not have to give that to anybody. It remains privileged. And it remains privileged until you tell somebody about it. So when you tell your wife, let me tell you what the lawyer said about the construction defect suit. Or let me tell you what the lawyer said about this lawsuit that the association's being sued. Or let me tell you what the lawyer said about the lawsuit the association's bringing. Or let me tell you why the lawyer said we can't allow these types of offenses. As soon as you do that, not only have you waived the attorney-client privilege for you, but you've actually waived it for the entire association. So be careful when you're dealing with attorney-client information. And also, your duty to maintain confidentiality remains even after you are off the board of directors. So if you get voted off the board of directors, you resign, you just get fed up and you throw up your hands, you say, I'm out. You're not allowed to go to your, circulate a flyer in the neighborhood saying, hey, party at my house. Now that I'm off the board, let me tell you about all the confidential information I have. If you receive it in your capacity as a board member, it remains confidential even after you are off the board. Board meetings. This one we get more questions than anything else. Board meetings are open to all unit owners except for the following matters. If you're discussing personnel matters, if you're discussing an employee matter, and we've looked at this as I think a number of other firms, if you're discussing a specific property manager, not the property management company, you can close the board meeting. If counsel is present to provide legal advice regarding pending and prospective litigation, you can close the board meeting. You are not allowed to close the board meeting if counsel is present if you are not discussing pending or prospective litigation. Can't tell you the number of times we receive requests from associations that say, hey, John, we're having a lot of problems. We want to discuss the problems we're having internally on the board. Can you please come so we can close the meeting? And you have to tell them, look, unless you've got pending and prospective litigation, you can't close the meeting, and counsel being present doesn't allow you to do it unless you're dealing with pending or prospective litigation. If you are closing a meeting, you still have to provide notice of the meeting. You ought to indicate on the notice that it is closed so people don't show up, and you need to indicate what the subject matter of the closed meeting is, such as discussion of personnel matters, such as discussion regarding pending litigation, or litigation dealing with developer, or litigation dealing with unit owner, over a fence, something like that. Other than that, you can't close the meeting. If you are in a closed meeting, be careful. You're going to have conversations and then you begin to drift. And when you drift to another topic, if it's a topic in which you can't close the meeting, then you have to reopen the meeting or stop and wait until you're having an open meeting to discuss it. Now, keep in mind, that's when you can close the meeting. Otherwise, all meetings are open to board members, to unit owners or members of the association. And if they're open, notice has to be posted. So for instance, John, we're holding a workshop meeting. We're not going to make any decisions. If you have a quorum of the board together, you are hosting a board meeting, and that board meeting needs to be open. If you walk out of the board meeting, a quorum usually is the majority of the board. So if you have a 5-member board and you have 3 members talking about board business, you are having a board meeting. That has to be noticed, and it has to be open to the membership. So when you leave the meeting and 3 of you members out of a 5-member board get together and start talking about the board meeting in the parking lot of the meeting, where the meeting was, you are having a board meeting that has to be posted and open to the membership. If you wind up having a party for the holidays and it's of the board, or there's 3 board members talking and they're talking about their holiday plans, they are not having a board meeting. If you drift into the conversation of the association, you're now having a board meeting, regardless of whether you're actually voting or not. You cannot do it unless it's posted and it's open to the entire membership. So be careful on that issue. Classic example is you're having trouble with the landscaper. You want to walk around with the landscaper. 3 out of 5 board members meet the landscaper outside of the property, to walk the property where the problems are with the landscaping company. You are having a board meeting that needs to be posted and unit owners are allowed to attend. If 20% of the unit, the attendance of a board meeting also includes the right to speak at the board meeting. So if in fact you're having a board meeting, unit owners have the right to speak. I always say the right to speak is not the same as the right to inquire. So if you're in regular board meetings, no problem, everything is going well. If you're having substantial problems in board meetings, you need to lock down. And what I normally do in that situation is I like there to be a motion, a second. I get the motion on the table. The board discusses it before the board votes. I like to start at the room and go left to right or right to left and get everybody's comments. I think this is a bad motion for the following reason. This isn't a good idea. I think this is a great idea. Take all the comments one-to-one. Don't respond to individual comments. Just take them all. If people ask you questions, you're not obligated to answer those questions, but you are obligated to let them speak for a period of time on the issue. We usually limit it about 3 minutes, and we like to do it while the motion is taking place. My classic example on this is that when I was president, we decided we were going to allow all comments to be made at the end of the board meeting. We're discussing an irrigation issue we're having. I got some guy that looks like Horseshack and Welcome Back Cotter raising his hand. I don't know how many of you have ever seen that, and I'm not calling on him because we're taking all the comments at the end. We make a decision on the landscape, on the irrigation system. And at the end, when I take the comment, he sits back and says, look, I got to tell you, I own an irrigation company. This is not what the problem is. Let me tell you what the problem is. This is what you need to do to fix it. And from that idea, I wound up saying, let me get the comments before the board makes the final vote on it, because people want to discuss it. People ask you questions, you let them know. I'm happy to give you another 2 minutes to anything else you want to say, but don't get sucked into answering the question. When you're done getting all the comments, then make a decision which one of the questions deserve an answer. Answer those questions if you want to. Bring it back to the board and take your vote. 20% of the unit owners forward a petition to the board and ask the board to address an issue. The board must address that issue within 60 days. Just because 20% of the unit owners want you to address something doesn't mean you have to agree to do what they want you to do. It may mean that 20% want you to do something, but 75% don't want you to do it. They're just not showing up at the meeting. And another 5% could really care less whatever you do. So when after you listen to what the 20% want, if you wind up getting a petition, it doesn't mean you have to take the action they want you to take. But it does mean you need to listen to them and consider what they're asking you to do. Conducting a meeting, you actually have to have proper notice. And believe it, we get it. Number one, what does a notice have to have? What type of meeting is it? Is it a board meeting? Is it a membership meeting? Is it an ACC or an ARC meeting? Is it a budget committee meeting? Is it a finance committee meeting? So you need to put the actual type of meeting you're having to be proper notice. Number two, you actually have to indicate where the meeting is, even if you have the meeting the same place each time. So if it's a place that has an address, put the address of the place, such as the public library, such as the religious institution next to the association, such as the main clubhouse of the association, or lobby A in a condominium or other type of a position. But make sure you have the location of a meeting. Notice does no good if you do not have a location. Same thing with respect to time. Different meetings require different periods of notice. Check with your property manager. Your property manager usually knows, but if they don't, they will check with counsel. Budget meetings, annual meetings, board meetings, depending on what's being discussed, all may have different time requirements that you have to provide notice. Some may be 30 days, some may be 14 days. Board meetings are generally 48 hours, but they're 14 days if you're discussing restrictions on unit owner use or use of their property. So you want to look at that and make sure you have the right time period. So you're going to want to check the statutes, the bylaws, the decks, and you want to check with your property manager. If your property manager doesn't know, they will generally discuss the matter with counsel. You want to provide an agenda. Condos, you got to post the agenda with the notice. Homeowners associations are not obligated to post the agenda. If you're in a condo, unless there's an emergency, you are not allowed to vary from what's on the agenda. You actually have to make sure you have a quorum. If you do not have a quorum, you're not authorized to conduct business. If you have less than a majority of the board of directors, you're generally not allowed to have a board meeting, and you've got to continue it or renotice it for a different time. If you're having a membership meeting, you actually have to have a quorum to conduct business. Usually that allows people to appear by person or proxy. So you've got to count the proxies, count the people. If you have the quorum, proceed. If not, you may have to continue it to a later date and potentially even renotice it. Make sure you have adequate minutes that are prepared. I've always said minutes, less is more. What do you want to have in your minutes? You want to have what the motion is. If you are the secretary of the association, make sure you know what the motion is. So don't take a second until you've repeated the motion back, such as, I move to foreclose on the following properties. I move to proceed with the contract for such and such vendor. Make sure you as the secretary have the actual motion. What is not a proper motion? I'd like to move as the president requested, or so moved. Make sure you know what the motion is. After you've written down the motion, then take the second. Note who made the motion, note who seconded the motion. Then have the discussion. You don't need to put the discussion in the minutes. So you don't need to indicate so-and-so thought it was a stupid motion for the following reasons. So-and-so replied, you think it's a stupid motion? Let me tell you what's stupid about you. That does not have to be in the minutes or the reasons people are voting for or against the motion. You just need the motion, the second, and then who voted in favor and who voted against. And you need to actually indicate who voted in favor and who voted against, such as the motion passed unanimously. The motion passed with the following 4 directors voting in favor and the following 3 members voting against. And that's what you need in the bylaws. Generally, you don't want to put discussion or other things along those lines, which always can create a problem later. It can create a problem as people are discussing whether they want to approve the minutes or not. Voting at board meetings. Directors have a duty to vote or abstain due to a conflict. Abstaining means you're not taking a position regarding the motion itself. So I always said, if you totally hate and despise your neighbor, you may want to abstain due to a conflict if you don't think you can vote in the best interest of the association. But the opposite is also true. The fact that the issue that comes up to foreclose on your neighbor or bring a suit due to your neighbor's violation, and you're particularly close with the neighbor, they visited you in the hospital, you've gone on trips or cruises with them, they may be too close to you and you may have trouble voting. And as a result, in those situations, we recommend that you consider abstaining from the vote, such as, I am too close to, or I'm good friends with such and such a person, therefore I abstain. And then you can tell the person when it came up, you were too close to them and you thought it'd be in your best interest not to vote either way. Condos, directors who are presumed to vote for the assented action unless they vote against it. Any good secretary will ask before they move on after the vote who voted in favor and who voted against. Minutes. The minutes must show who voted in favor, against, and who abstained. And directors are not allowed to vote by proxy. Members can vote by proxy at membership meetings. Directors may not vote by proxy, and they may not vote for secret ballots other than for the officers who's going to run the association. So if you're voting for who's going to be president, secretary, treasurer, etc., that can be by secret ballot. If not, you need to make sure that you are proceeding in the appropriate fashion, and that there's a level of accountability so that unit owners can know who's voting and how they're voting. electronic participation in meetings, condos. And you are allowed to participate in meetings, including telephone, video conference, or similar real-time electronic manner. So as long as the director who's participating can hear the other directors and the other directors can hear that unit owner, you are allowed to appear electronically. And generally, even though there's not a specific statute on it, we believe the same applies to homeowners associations. It's not just required, but you are allowed to allow it. The goal is to make sure your directors have the ability to attend, even if they're not here. And it works. We have people that are attending board meetings from the hospital, from up north, from Canada, from Europe, from Taiwan, from Tel Aviv, you name it. We can have this function. Sometimes it's just a speakerphone on the table. Sometimes it's a commercial speakerphone that's put in the middle of the table. Sometimes it's by video conference. Sometimes people just put an iPad up with the person's face, Skype them in, and it looks like they're looking at the membership just as if they were sitting there, except it's via iPad. Board members may use email to communicate, but you're not allowed to vote via email. So you can communicate with each other via email, but you're not allowed to vote on things via email. By the way, 617-0821 allows you to make certain decisions in writing if you sign it. And we've indicated typing your name at the bottom of the email constitutes such if you wind up having a unanimous, it's unanimous among all board members. So if you have 7 board members and the pump breaks for the sprinkler system, and the president doesn't have enough authority to replace the pump, which is going to be $7,500, nothing says the president can't send out an email saying, see attached proposals. I'm recommending we go with proposal B. Rather than calling a board meeting, does everybody agree? And if everybody assents and they write their name on it, then those writings become part of the official records, and you can proceed with the pump, but it's got to be unanimous. If you can't get a response from somebody, you got to have the meeting. If somebody says, no, I want to go with proposal C, not B, you have to have the meeting. If somebody says, yeah, I'm happy to agree with it, but I want the following, that becomes a conditional acceptance, and that doesn't work. The acceptance of the agreement has to be unconditional. By the way, there's always an issue. If you can't vote by email, how can you give unanimous consent by email? We've looked at this carefully. I believe most attorneys have concluded that giving a unanimous consent on an issue is not necessarily voting per se, and that can be allowed. We also recommend that you ratify the decision at your next board meeting. Insurance. Associations shall use their best efforts to obtain insurance to protect the association's property. Best efforts means just that, best efforts. And be very careful not using the best efforts. You've got a lot of money at stake and a lot of issues at stake. So make sure you have the appropriate insurance to cover what you need to cover. Association may obtain liability insurance for directors and officers. Tell you, I serve on a number of not-for-profit boards. First thing I always ask, do you have D&O, director and officer, or E&O, errors and omissions policies that cover the directors in case of a mistake? You want to make sure you have it. That policy will provide the defense and possibly pay the dollars if you wind up getting sued or if the suit is successful. By the way, you're in charge of obtaining insurance. My recommendation is you bring your insurance agent in once a year or once every other year to discuss your policies. There's a lot of different policies and there's a lot of different decisions you have to make. You have to determine, for instance, what is the deductible. The higher the deductible is, the cheaper the insurance is. But if you're going to have a high deductible, make sure you have the money in reserves to pay for the deductible if you need to use it. Does you no good to have a $50,000 deductible and only $5,000 in reserves, or not have the money to pay for the deductible when you need it, even though it may make the insurance cheaper. 2, you can overlap insurance or things. So for a lot of times it may be, let me get insurance up to a $500,000 or $1 million here. Let me get insurance from $2 million to $5 million here. And if you're not careful, all of a sudden you got a gap between $1 million and $2 million. So you want to bring your agent in. You want to discuss what's the value of the property. What am I covering? Is the insurance that I'm purchasing have enough money to cover me if I get hit by a windstorm or if a fire erupts or something like that? So my recommendation is actually bring in the property, your insurance agent once a year or every other year, just to make sure you have proper insurance. I can't tell you the number of times that as counsel, what level of insurance should I have? And my response is, I'm not your insurance agent. You need to talk to your insurance agent. Good lawyers aren't telling you the dollars you need to have for insurance. They're referring you to your insurance agent and reach a conclusion with them. Condos and HOAs, you have to have a fidelity bond to cover the president, secretary, treasurer, and all persons who actually touch funds. And it has to be for the maximum amount of funds that you are covering at any given time. So if you collect all your assessments in January and then you spend them down during the year, the bond has to be enough to cover the maximum amount of assessments you have on January 6th. You know, you'd like to think that people don't steal money, but I've got to tell you, it happens. And so you need to be prepared for it. Classic example is we have a treasurer in one of the associations we're representing. She's short a little bit of money on her mortgage. She needs some extra money to make the payment in June. She borrows some money from the association. She pays it back 3 days later. Same thing happens, but it's a little more money the following month. And about 6 months later, she's into the association for 3 mortgage payments. It's criminal. You cannot do it. But if the money disappears, you're not covered unless you have the appropriate insurance or bond. Make sure you have the bond. It does occasionally happen. And as a result, they're not expensive. So my suggestion to you is be very careful waiving the bond itself. Maintenance of the condiment elements. Condos, you must maintain the common elements. What does that mean? That means those elements, and the same thing for associations, those pieces of property or those areas that you are required to maintain, you actually need to maintain them, and you have to have enough money to maintain them. If you're not maintaining them properly, people can get injured. If you're not maintaining them quickly enough, it is a stitch in time saves 9. The longer you wait to paint or caulk a building that needs painting or caulking, the more expensive it's going to be when you need to do it. Make sure that you're conducting the maintenance in a manner in which it needs to be conducted. By the way, declarations have different requirements. And this also, by the way, goes for homeowners associations for limited common elements. Most homeowners associations don't necessarily have limited common elements, but if you do, this applies. Look at your declaration on how you cover a limited common element. What is a limited common element? It's a part of the property that is not owned by the unit owner, but of which the unit owner may have exclusive use. The classic example is a balcony. You may not own your balcony. It may be owned by the association, but only you are allowed to use your balcony. Other unit owners are not allowed to walk through your unit to use your balcony, even though you don't own it, and even though it's a common element. It's a limited common element. Same thing with parking spaces on occasion, storage areas or closets. And then occasionally you'll see it in certain high-end condos with respect to elevators. If the elevators only serve, a quarter of the building, it may be that quarter of the building is responsible for the maintenance of that elevator. Sometimes you see it with stairwells. The 4 units that own that stairwell are responsible for that stairwell. The association's documents will tell you how you maintain that stairwell or those limited common elements. Sometimes it's done by the association. Sometimes it's done by the unit owner or a group of unit owners that use that limited common element. Alterations to the common elements. You in a condo are not allowed, unless your decks say otherwise, to alter the common elements without a 75% of the voting interest agreeing to it. So for instance, if you're living in a condominium that was built in 1987 and the color scheme that you have on the building, Tampa tan on the body and a little darker around it, may have been cutting edge color scheme back in 1987. If you want to change that color scheme, you need to get 75% of the voting interest to agree that you can change it to the color you want to change it to. You are not allowed just to change it with a board vote unless your documents say otherwise. If you have tennis courts and you want to change it to pickleball courts, that's a material alteration. You need to get 75% of the vote before you change it. Now, the flip side is in homeowners associations, generally the board, unless the documents say otherwise, has the ability to make material alterations to the common elements without necessarily obtaining the approval of the membership. And I've seen the decisions where an association will turn around and in a hallway, they'll take down wallpaper and they'll put up some other color scheme, and somebody complains to the Division of Business Professional Responsibility, Division of Condos, Timeshares, and Mobile Home Parks, and the division issues a letter to the association that says you have 60 days to obtain the approval of 75% of the membership, or you're required to put it back. And the law was recently changed, indicating you actually have to have the vote before you make the change itself. This is going to be the easiest thing you are going to learn today. You cannot commingle funds. You can't commingle them with your own funds. Other officers or directors can't commingle their funds. The manager and the manager's employees can't commingle the funds. If you look at the checks you have when you're dealing with Associa, you'll notice they're not in an Associa account. They are in an account with your name. And you are giving approval to Associa to issue the check in the name of the association. Associa is not able to keep one giant account where it puts the funds for all of its associations. Each association's funds need to be kept separately. HOAs, including the developer, can't commingle funds with his or her funds. Every month, dollars that come into the association must be kept accordingly in the name of the association. Letters of inquiry. This applies to condos only. If you get a letter of inquiry, a letter that's asking you questions, you have to respond in writing within 30 days of the receipt of the letter, 60 days if you need a legal opinion, 10 days after you receive a response from the division if you need direction from the division in responding to the letter of inquiry. The failure to provide a substantive response precludes you from obtaining your attorney's fees if you wind up subsequently arbitrating or litigating the matter. The board may adopt reasonable rules and regulations regarding the frequency. So let me give you a quick story of where this comes up. We are representing a small condo on the beach. A unit owner decides they're going to put up an air conditioner on the roof of their building, and the first floor is slightly adjutted from the second floor unit. So when you look out of the window, looking out on the Gulf on the second floor of the condominium, you look at the Gulf over the roof of the first floor. So when the first floor unit puts up an air conditioner on the top of her roof, it's blocking the view of the Gulf of the second story unit. The unit owner was told to remove it. The unit owner wouldn't remove it. And ultimately, the association brought suit requiring the unit owner to remove the air conditioner from the roof. We wound up going through a whole trial on this. Judge at the end of the trial ruled you have to remove the air conditioner and issued an injunction requiring the unit owner to remove it. The unit owner didn't want to remove it and still didn't remove it. So we had to go back to court and use the contempt powers of the court to enforce the order that the court entered, requiring her to remove the air conditioner from the roof. Finally, the judge looked at her and said, "Ma'am, I've been on the civil bench now for a few years. I can count the number of people that I have incarcerated on a single hand. Don't make me go to the second hand." And at that point, we agreed to get a receiver to remove the air conditioner and patch the roof. We then moved for our attorney's fees, which were well into the six figures. We went to the attorney's fees hearing. Before I went to the attorney's fees hearing, I got a letter from the other lawyer saying, "Hey, John, my client gave me this letter of inquiry. We don't see an answer. Can you show me where you answered it?" And I looked at it, and I get this pit in my stomach going, boy, this has, like, out of the 10 questions, there are 6 questions that are relating to the air conditioner. Why didn't it get answered? I don't remember answering it. So we wound up calling the lawyer that had the case before we had it, and the lawyer that actually got the letter of inquiry. We came in late to this case. And the lawyer, when I talked to her, said, look, John, we were already in litigation on something else when I got it, so I didn't think there was really a point to respond to it. Because the association didn't respond to it, there was a huge question whether we were going to recover the attorney's fees that the association spent requiring her to move the air conditioner. And we went to the hearing, and I got to tell you, sometimes these hearings are tense, and this was a tense one because we had well into the 6 figures at stake in attorney's fees, and it was going to be based on whether we had to give a written response to this letter of inquiry. After the argument, the judge ruled that while there were 8 questions or 10 questions that all related to the air conditioner, none of them related to the specific issue that was being tried and awarded attorney's fees in the association's favor. Be careful when you get these. Get that to the letter to your manager and your counsel on an immediate basis. If you don't, the repercussions can be substantial. Also, by the way, when you're answering the letter of inquiry, you actually have to answer it. So you're not allowed with substantive answers. So you're not allowed to question number 1. That's a really good question. I wonder if anybody knows the answer to that. Or we don't have to answer that. The answer is answer the question substantively that you're being asked in the letter of inquiry. Amendments of bylaws. The bylaws do not provide a method for amendment. Generally, you're required to have 2/3 in order to amend them. There's certain things that you can't amend without 100%. Condos and HOAs. You are not allowed to change or materially modify the units or the lots, the percentage of sharing of the common expenses, or the votes that a unit owner has without 100%. So for instance, if you have a 2-bedroom, 2-bathroom condo and your neighbor has a 3-bedroom, 1-bathroom condo, the board can't vote to give the other neighbor one of the bathrooms. That's a statement of the obvious. But you also can't change the assessment scheme. And the classic example becomes when there's a large association and you're on the board, you're in a 1,000-unit association or something like that, and you find out that the pump or the water fountain in the back pond went out because there's 3 unit owners indicating what happened to the water fountain. And you sort of look up and you go, boy, I didn't even know there was a pond back there, more or less a fountain. I never go back there. And you realize that out of the 1,000 units, there may only be 10 units that can see that water fountain. And it's going to be a $4,000 or $5,000 fix. So you look at it and you think about it. And he comes up, look, guys, you moved in here with a water fountain. We're happy to repair the water fountain, but it's not fair that all the unit owners have to pay for this. You're the guys that are benefiting it. You guys want to pay for it. We're happy to fix the water fountain. Makes total sense, except for the fact that if the association is responsible for fixing it, you have just changed how the assessments work and how the fees are split. If in fact it's an association expense, it's got to be shared by everybody, and you are not allowed to modify the percentage of shares of common expenses. So you're not allowed to do something like that. It comes up in ways that you normally wouldn't think it would. So you want to be careful. Homeowners associations, by the way, and I think condos also, if you're going to modify the manner of which somebody can use their parcel, you've got to give 14 days notice. Number 2, amendments now generally in a homeowners association, after they're recorded, they need to be mailed to unit owners at their address as reflected in the property appraiser's office. So if you're doing amendments of governing documents, make sure not only are you mailing them after they're recorded, but you're mailing them to the unit owner's address in the as contained in the property appraiser's records. And we've indicated that governing documents includes rules and regs. So if you're changing a slight rule, you need to go ahead and you need to mail it to everyone. Delinquencies. This is one of the toughest things you are going to do as on the board of directors, and that's dealing with delinquencies. When an owner falls delinquent, you have a number of things you can do. You can send a delinquency notice. If the property is being rented, you actually can demand the rent. And this came up a number of years ago in the Great Recession when people would own 30 units in a condo, realize they were going into foreclosure, not pay the association, but be making a fair amount of money from the rent of the units. The law was changed to allow both HOAs and condos to go ahead and grab the rent. And if the rent's not paid to you, you can actually evict the tenant. You would be surprised at the responses that we get when we do a demand for rent, such as, you know, actually my rent's only $10 a week. Or, well, I'm not really renting it. You know, what I'm doing is I'm a 1% owner in a land trust. And as long as I pay the land trust $1,950 a month, I can remain a 1% owner in the land trust. On those, we actually bring the claims. You're also allowed to foreclose a lien. In order to do a lien, you first have to generally send out a letter of intent. That's usually the letter that says, hey, you haven't paid your assessments. If you don't pay them in the next 30 or 45 days, we're going to record a lien on your property. And then if it's still not paid, generally we send we record the lien, and then we send a letter basically saying, hey, we told you if you didn't pay your assessments, we were going to record a lien. Here's your lien. And by the way, if you don't pay them in the next 30 or 45 days, depending if you're a condo or an HOA, we're actually going to institute a foreclosure action. We may institute a foreclosure action. We find that after unit owners get the first letter, if you have a fair amount, we usually get about 50% of the delinquencies cleared up with the first letter, about another 50 with the second letter. And then when we foreclose, we can usually pick up a number of other ones. You know, it used to be occasionally associations were winding up with the property. We find that happens in situations in which there is no equity in the property. As long as there's equity, rarely does somebody lose their property to an HOA or a condo lien. Before filing, we got to make a decision whether we want to foreclose, and usually we have to make a determination whether we want to usually go for a money judgment or a foreclosure. Foreclosure means that the unit gets put up for sale. And to be put up for sale, that usually used to take place on the courthouse steps. And I got a question that I'll answer in a minute. So you would put up the property for foreclosure on the courthouse steps, and it would be auctioned off. It's now done all online. Generally, we go for two types of judgments. One is either to auction off the property, or two, just get us a money judgment. So years ago, I was dealing with somebody in Hernando County where we filed the lien. They hadn't paid their assessments. We filed the lien. They still didn't pay. And we wound up filing the foreclosure action. I got a call from a guy that owned the property individually. He turned out to be a lawyer in Hernando County. And he told us, hey, John, let me tell you this. I'm underwater on this property. Go for the foreclosure. There's no value there. I'm just happy to get it off my hands at this point. And I'm thinking to myself, I'm going, hey, you know, that's actually pretty interesting. But I told him, I said, look, we're not actually looking to foreclose it. We actually are looking to obtain a money judgment against you. And my understanding is you're actually the owner of your law practice, and we're going after your law practice if it's not paid. And we wound up getting that check in the next couple of days. One of the questions I had is, hey, John, you know, do you institute a foreclosure proceeding if you've just missed a couple of payments? Our recommendation is that you start the collection process with the first letter of intent after an assessment is anywhere from about 60 to 90 days past due. The longer you wait, the more the assessments are, and the harder it is for unit owners to make up. So by the time you wait 3 years to go after the assessment, it gets substantially harder to collect the assessment. And now you're dealing with substantially more money. I also say this, and that is that you can't do this line of work that we do without hearing some of the very, very, very difficult stories relating to people that are losing their units. And they're heartbreaking. They really are. I can't pay my assessment. I find myself alone. my spouse always paid all the bills as we're earning the money. They just passed away. So-and-so has cancer. We're financially strapped. The goal of the collection process is actually collect the money. It's not to take the unit. And usually what we recommend, if somebody can get on a payment plan and straighten out within a year or so, the association should generally accept the payment plan so long as they remain current going forward. Nobody in our experience generally loses their unit to an association lien or foreclosure. And I say that because what happens when we do this is it's really a question that the unit owner has made decisions of what they want to pay and what they haven't, such as a cell phone bill, such as a car payment, such as an electric bill, such as a cable bill. And you don't want to get into that aspect of it. If they, with all the bills that the unit owner has, if they can't pay the assessment for the association, that a lot of times is an indication that the unit owner is just living above their means, and they just may need to downsize or make other differences in the way that they're living, because they may just be living over their means that doesn't allow them to pay for everything, and they've just chosen out of all of the expenses, it's the association that's not going to be paid. So we want you to be careful. We want you to be careful, and we want you to think carefully before you're moving forward. But generally, we recommend 60 to 90 days out, start the collection process. Most lawyers will talk to you before the foreclosure is filed, but the longer you wait, the harder it is to collect. And if you're waiting to collect, that generally means that everybody else is subsidizing the unit owner who's not paying. If you have assessments on your books that are 2, 3, or 4 years old, you really need to look on why those aren't being collected. Generally, we should be able to clean these assessments up within about 9 months to a year, barring a bankruptcy proceeding. So if you have substantially old assessments, you want to look at it and you want to find out why it's taking so long to collect them and get into the specifics, such as somebody died and nobody's taking the house over. Or number 2, they're in a Chapter 13 bankruptcy plan and they're going to pay it over 5 years. But look at it. You don't want to have a large list of receivables or high numbers of which you have to collect. Most law firms do this type of work on a contingency, meaning if they don't collect from the unit owner, they're generally not charging you. Give me 1 second, please. Owner delinquencies. If somebody's not paying their assessments, you have a couple of options. Number 1, not only can you go for a foreclosure and not only can you go for a money judgment, but you can also suspend voting rights and delinquencies. And by the way, I'm going through this somewhat quickly. Please let Paul know, and he's going to be happy to send you a copy of this presentation in the PowerPoint form, and you can look it over at your leisure. Just make sure you send him an email and let him know. Number 1, if an HOA, a unit owner, is not paying their delinquencies, you have the right to suspend their use to the common elements. When you suspend the use to the common elements, that means things like fitness center, clubhouse, pool, docks, things like that. What can't you suspend? You cannot suspend their use to go through the gate or to use the roadway to get to their unit or use the stairs of the association or use an elevator or things like that. You can't suspend their right to use their parking space. You can't cut off their utilities, but you can suspend the use of the amenities. Number 2, you generally have to give notice on that. You also have the ability to suspend rights not only for both for delinquencies and for violations if you're set up to do it. And if an owner is more than 90 days delinquent in paying any monetary obligation to the association, it totals more than $1,000 in an association, in a condo, you can suspend the unit owner's voting rights. Same thing with any delinquency 90 days in an HOA. So if somebody is more than 90 days past due, you can vote at a board meeting to suspend their voting rights. If you vote to suspend the voting rights, the quorum requirements go down accordingly. So if you have 100 units and you suspend 10 units, and you need 50% for a quorum. When you had 100 units, you needed 50 units plus one to have a quorum. When you suspend 10 units for not paying their assessments, the quorum goes, the number of units needed for a quorum is still 50%, but now it's 50% out of 90. So instead of needing 51, you now only need 46. Does everybody understand? If you have questions, just let me know. Owner violations, fines, and suspensions. We get a lot of questions on this. Fining, I will say the following. Fining works as follows. Number one, the goal of fining is not to collect the fine. The goal of fining is to bring the unit owner into compliance. It's not to be used as a revenue source. It's used as sort of enforcement. How does fining work? Normally, it's the board of directors that votes to levy the fine. So the first thing the board needs to do is, if you're fining, the board actually needs to vote to levy the fine. The fine can be up to $100 per violation and up to $1,000 for a continuing violation that occurs over a 10-day period. So if you have a house that's painted the wrong color, you can proceed with a fining of $100 a day up to 10 days for $1,000. If you're dealing with garbage cans that are left out, you just can't do a continuous fine for 10 days. You're going to need to have proof that the garbage cans were left out over a period of 10 days. And usually what we recommend is that you have pictures or something like that. Same thing with the parking of commercial vehicles, leaving towels on balconies, failing, in HOAs, if you're failing to clean a roof, you can take a picture on the first day and the 10th day, and you can surmise that the same stain has been there in between. It wasn't a new stain. But if you're going to go, you want to have proof that it's been actually 10 days. After the association fines, then it needs to go to a fining committee. And the fining committee either confirms the fine or does not confirm the fine or rejects the fine. Fine is rejected, there is no fine. If the fine is confirmed, the fine stands and generally needs to be paid within 5 days. The fining committee can only give a thumbs up or a thumbs down. It can't cut the fine in half. It can't abate the fine to make sure there's no other violations in a period of time. And these always cause tension between the fining committee and the board. So the classic example that you have is that somebody painted their house the wrong color. You wind up board votes to fine them. You levy the fine of $1,000. It goes to the fining committee. The people then come in. They are in tears. Their daughter is in cancer treatment. They just knew there was a problem with the house. They know it needed painted. They were just too busy. They didn't focus on it. And they want you the fining committee, to consider waiving the fine. Fining committee looks at it. They've already repainted the house. Fining committee looks at it, makes a determination. Look, you were in violation. The board has voted to levy the fine. We're not going to waive the fine. You just need to pay it. We are sorry. And everybody on the fining committee is holding back tears because they really feel sorry for the person. The person gets annoyed. They go to the board. They say the fining committee wouldn't waive the fine. Would the board waive it? The board decides, look, you brought the house into compliance. Why do we need the fine? So the fining committee waives the fine. I'm not the fining committee. I'm sorry. The board waives the fine. Why? The house is in compliance. There's no reason to push further. Now, all of a sudden, the fining committee goes ballistic. How could you have done this to us? We had to take a night off. We all discussed it. This was the hardest decision we've had. And now you're just going to go ahead and you're going to waive the fine? Why would you do that? The answer is the fining committee did what the fining committee needed to do. It's the board's discretion afterwards whether it wants to waive the fine or not in that situation. Fining committee rejects the fine. There is no fine. Game over. Start over. Fines are due, I think, within 5 days after they're levied for payment. Bids and contracts. You're under an obligation to obtain competitive bids. Association condos must, and by the way, on fines for a condo do not become a lien. For homeowners associations, they can become a lien, but they have to be at least $1,000 before they can become a lien. Obligations to obtain competitive bids. I always say that, or the law is on this, I'm sorry, condos, you have to obtain at least 2 bids if the work or services for a specific item will exceed 5% of the annual budget, including reserves. HOAs, you got to get 2 bids if it's more than 10% of the annual budget. Just because it says 2 bids doesn't mean you only have to obtain 2 bids. We recommend obtaining 3, 4, 5 bids, and that'll give you an idea on what the real price is. Number 2, you are not a governmental entity. And because you are not a governmental entity, you are not required to go with the lowest bidder. So the fact that you check out the references on a specific bidder and you find out they've been sued on the last 4 contracts and the reference is saying these guys are terrible, don't use them, that may be a reason why you do not want to go with the lowest bidder. There's also other reasons why you may not want to go with the lowest bidder. You've got a landscape proposal out and you have a irrigation proposal out, and you wind up going with the landscaper that has the lowest bid for the landscape. You then 3 months later look at the irrigation proposal. All of a sudden you realize that your landscaper is also bidding on the irrigation proposal, but they happen to be 1.5% higher than another company. You may want to go with the lowest bidder. You may want to go with the landscape company because you know to do the irrigation service, because you know that if you have a different company doing irrigation and landscape, every time you have a broken sprinkler head or a cracked line, the irrigation service is going to tell you it's the landscaper's fault, and the landscaper's fault is going to tell you the irrigation company's responsible for it. So there are reasons why you may not want to go with the lowest bidder. By the way, you do not have to send out bids for employees of the association, attorneys, accountants, architects, community association managers, timeshare management firms, and engineering and landscape architect services. Why don't you have to bid on those entities? We looked at this a while ago, and I think the determination that we had was that these were the companies or the businesses that seemed to have, or industries that had the best lobbyists at the time this statute was passed. Conflicts of interest. Condos, and this primarily applies for condos, but if you're on an HOA board, look at this carefully. This gives you a heads up you may have a problem. You are not allowed as a board member to bid or enter a financial relationship with the association if you own more than 1% of the equity shares in a company. So an association may not employ or contract with service providers that are owned or operated by a board member, a person who has a financial relationship with a board member, or a close relative. Close relative is defined by 3 degrees of consanguinity. What is that? That is if you go to the family tree and you sort of count 3. So you go from your mom to you to your child, and your child, your child to a grandchild. Or you go from you go up from you to your parents, then your parents to an uncle, and then an uncle to their child, which makes it a cousin. You got to get more than 3 degrees of consanguinity away. Can't enter service contracts. Don't do it. By the way, if you have a 401k or something like that, or an investment account, and you have Verizon, it doesn't mean you can't turn around and enter a contract with Verizon, because you own less than 1% of Verizon, and that's not going to create an issue for you. Contracts with majority owners. If you're dealing with majority owners, let me know. And that generally means that there's an owner that owns more than 50% of the units. There's special requirements that they cannot do. And associations are not allowed to attorneys are not allowed to represent the association in a condo and the management company. This got passed, I think, about 4 or 5 years ago by the legislature. We were representing a number of association management companies, and we decided when this was passed, we either had to go on the management route or the association route. We decided we would go on the association route. Management companies were hiring us because they could see what we could do when we were representing the association, but we had to pick one or the other. Therefore, we are not representing at this point any management companies, but we were able to get them to competent counsel. Conflicts of interest, purchasing of units. Guys, if you're a board member, do not purchase in a foreclosure sale or obtain a deed in lieu of a foreclosure in the association in which you are on the board. If you want to invest your personal wealth in acquiring property, do it at the condo or the association across the street. Don't do it in your own association. It is just fraught with problems, including not accepting payment plans because the president has just acquired another unit or something like that. Same thing deals with any contracting party. So it includes management companies, maintenance workers, maintenance companies, things, or people along those lines. Just don't buy a condo in a foreclosure sale or a deed in lieu for unpaid assessments if it's in your association. This is where people get into trouble, and this is where you potentially start waiving the privileges that you have from liability in a not-for-profit corporation. Director conflicts. Directors and officers of an association and their relatives, if you're going to wind up in a conflict situation, in a conflict that is waivable in a condo, you need to disclose it to everybody. And there's a rebuttable presumption that there is a conflict if the following occurs without notice. The officer, director, or relative of officer or director enters into a contract for goods or services, or the relative or of a director or officer holds an interest in a business that conducts conducts business with the association. So back to your daughter owns the landscape company. That is a conflict. Don't proceed forward with it. If you want to try to do it, you can do it. But at that point, you need to turn around and you need to make sure that you've provided the association notice and all the directors, you give them all the documents, the contracts, everything else, and that the board then will discuss it and vote on it. You can be there for the discussion. You can be there to make a presentation, but you need to leave the room for dealing with the vote itself. But my advice to you is talk to your counsel if this comes up and be careful. More often than not, even if waived, we find problems in these situations, even if they come from some unintended consequence. We recommend you not get into these issues or you wind up getting yourself into trouble that you may very well resent later. And these are the things that create substantial liability for all involved and can quickly fractionalize a board. So be careful. Failure to disclose. If you don't disclose it, you are deemed removed from office, number one. And number two, even if it is disclosed, 20% of the membership can vote to cancel the contract. That may not seem like a big deal, but if it's a front-loaded contract, such as a landscape contract, and you wound up offering, to replant the entryway beds on the monument signs that are coming to be about $40,000, and you're going to make that up over the period of the contract, it's not going to help you if 20% of the membership moves to vote to cancel the contract the month after you've installed all the plants. They have the right to do it, and then you're out those type of funds. Official records. Association must obtain official records for 7 years. You can adopt reasonable rules regarding how often they can be inspected. You can't require, and even though it's in the HOA statute, it's not in the condo, but the same applies. Somebody who wants to look at the official records of the association does not have to give you a proper purpose to look at them. They have an automatic right to look at the official records, even if the purpose for which they want to look at the records is nefarious or improper. You have to produce the records. What condos, a renter who is not an owner or not a member of the association has the right to inspect and copy the association's bylaws and rules. And as of January 1st, associations, condos that are over 150 units must actually post certain records that are on a website that are inaccessible to the general public, but are available to the members of the association. You generally have to at least allow one full day a month. So what are the official records? The official records are generally the governing documents. That means they're the decks, the articles, the bylaws, the rules, and the regs. They are meeting minutes now, and the meeting minutes now go back not just 7 years, but from beginning of the association. A list of all unit owners, current insurance policies, all contracts, all bids received for last year, accounting records, including itemized records and receipts and expenditures, and a statement of every other unit owner in the association that shows what they paid and when they paid it and if they owe any money. All of that has to be made available. In addition, and included with that is any other document that is used by the association with respect to a written type of record. So it's almost anything that is involving the association business. Generally, property managers will keep this. Associate does a good job. They keep your records. And if you wind up getting an inspection request, they can handle those inspection requests. On difficult ones, lawyers will get involved. Records are that are not available, meaning what don't you have to produce if you get hit with a records request, meaning a unit owner wants to look at records, you don't have to produce the following records. Records that are covered by the attorney-client privilege. That can remain secret. You don't have to give that to a unit owner. Same thing with lease and sale applications, same thing with personnel records, such as not of a management company, but of the individual manager, including disciplinary issues, payroll, health insurance records, medical records, personal identifying information, just like the information is confidential, including social security, driver's license, credit card information. You don't have to give telephone numbers or email addresses, unless, of course, you're publishing a directory and you're already publishing that information. Then that information has to be disclosed. You don't have to give up your passwords. You don't have to provide access to software systems that can be manipulated by the unit owner. But if you're not going to provide access, you do have to be able to provide the information in some alternative form. You have to respond to the records request within 10 working days after receipt. 10 working days. Records must be made available within 45 miles of the community or within the county in which the community is located. So if you wind up getting a records request by the unit owner that every single person on the board hates and despises, you can't say we're happy to produce the records and they're going to be produced in Broward County. They have to be within 45 miles or the county in which the community is located. The failure to provide access within 10 working business days creates a rebuttable presumption of the failure to comply and can subject the association to $500 plus attorney's fees or actual damages. Good lawyers that know what they're doing are going to wait until the 10 days pass. And then they're not going to necessarily, if you're in an HOA, give you any more notice. They're just going to file the lawsuit, and now you're on the hook in all likelihood for $500 and the attorney's fees. And generally, the attorney's fees are going to usurp the amount of the $500. You need to comply timely. We just had one of these recently where it was a condo, and we gave them a warning. We told them, look, we want the attorney's fees records. They said, look, Mr. Ellis, you're in litigation with us. We don't have to give them to you. We said, yes, you do. We sent them a second letter with a petition. They didn't think they had to do it. We filed the petition, and we just wound up getting our attorney's fees and an order to the association to produce the records. But the one that creates the biggest problem, and I'll just go to a war story very quickly, is years ago we had a guy that was renting out his condo in Manatee County and off the beach. And the association was helping renting it and keeping all of the rental records for the unit owners. It was going ahead, making sure everybody who showed up had keys and everything else, collecting the money and remitting it to the unit owners. And it was a service that the association was providing. The individual wound up getting a letter from the DOR, Department of Revenue, asking him if he had remitted his sales taxes for the leasing of the unit. So he went to the association, he asked them for the records. He couldn't get the leasing records or the proof that the association was collecting sales tax and remitting it to the Department of Revenue. And he made a number of requests. He just couldn't get it. He was a lawyer out of Pennsylvania, I believe, and ultimately contacted our office. And we looked at it and we couldn't understand why the association wasn't producing the records. Meanwhile, the time was ticking in which this individual had to get this information to the Department of Revenue. So we looked at it. The letters looked good. We didn't see a problem. We recommended to have our firm send one more letter to the association to get the documents. But this time we sensed something was wrong, so we didn't just ask for the sales receipts, but we asked for all of the official records. And because the time was running closely, we wound up sending not only an associate of mine down, but we also sent an accountant that would pool the exact documents that were needed in case there was any type of question of what was needed. The associate we sent down was 8 months pregnant. They arrive in Manatee County. They arrive at the association, and two things happen. Number one, the association produces 89 pages of documents. And number two, they will not let the 8-month pregnant associate use the association bathroom. So she has to drive to a gas station to use the bathroom. We get back, we look at it, we file a complaint with the division for failing to produce documents. Division, because it happens to be with the a condo, it's called an arbitration that we file. And after we file the arbitration, we receive 5,000 pages of documents that are sent to us about a week or 2 weeks after the association realizes we filed the petition. We look through the documents, and one thing is clear in the 5,000 pages. There are no records relating to remittance of sales tax by the association to the Department of Revenue on behalf of unit owners. And as a result, we wind up in an arbitration that takes place in one of our conference rooms in our law firm. You have the association president and treasurer with their counsel on one side of the table. I am there with one of the associates and two clients on my side of the table. And we have an arbitrator in Tallahassee that's listening by telephone. And it becomes readily apparent in the middle of the arbitration that even though we must have had 800 pages of bank records, none of them related to the rental program, because the rental program documents were in a separate bank account and had not been produced. The arbitration ended, and ultimately at this point, the what do you want to call it? The arbitrator ruled that they didn't produce the documents, that the time limit to appeal the decision of the Department of Revenue had passed. They wound up finding not the $500 for us, but $11,500, which incorporated the taxes that were not paid, along with interest and penalties, and then awarded us approximately 5 figures in attorney's fees. That resulted in the president of the association, the treasurer of the association resigning from the board of directors, and I think ultimately selling their units. Be careful when you get these. The rule is you have to produce the documents whether you want to or not. There's 2 ways to do it. One way is to just send the unit owner the documents they're requesting. The other way, if you're really in a fight or this is going to be problematic, put the documents out on a table. You don't shuffle them, you don't change them, and you allow the unit owner to go through and look for the documents and mark what they want copied, and we'll arrange to have them copied for the unit owner. The inspection can take place at the property manager's office, at a clubhouse within the association, or occasionally they take place in our office, and we put a paralegal in the room to make sure nothing's taken, but not to discuss the matter with the unit owner. Owners have a right to obtain copies. You have to let them make copies. Condos may impose a fee to cover the cost of the copies. Homeowners associations can cover a cost of copying and the cost for personnel to retrieve the copies if the time spent exceeds 1/2 hour and the cost of the personnel is not over $20 an hour. Personnel costs may be charged for requests that result in a copying of 25 or fewer pages. The HOA may charge up to 25 cents a page for copies made on an association copier. Budgets and reserves. Association must prepare an annual budget which shows the estimated revenues and expenses for the coming year. The budget is an estimate that will guide the board in making your decisions, and the proposed budgets must be maintained in your official records. Generally, and almost always, the board is the entity that actually adopts the budget. Homeowners associations, you have to provide each member with a copy of the annual budget or a written notice that it is available at your request at no charge. Condos, you actually have to send a notice of any board meeting in which the budget will be voted upon. And the notice must be mailed or electronically delivered or transmitted. You have to give 14 days notice, and both budgets for HOAs and condos need to indicate what the reserves are, if any, and and showing the reserves, what the budget is if the reserves are fully funded. You actually need an accountant to have an affidavit that the notice has been appropriately mailed. Budgets. The revenues need to include the assessments, the interest, insurance proceeds, any type of income you have. Expenses include annual condo fees paid, insurance costs, administration and management expenses, maintenance expenses, expense that you may have paid renting out common facilities for meetings, taxes, security expenses, or any other type of expense. I got to tell you, I used to spend, when I was president, an awful amount of time looking over the budget, and then making some awfully minor adjustments until it dawned on me that my property manager for the association totally knew what that budget was. So rely on the property manager. You want to look over it, you want to ask your questions, but usually the property managers are awfully good at understanding what your budget is, where you're down or up, and you want to look if there's any type of variation. If so, why? Reserves. This can get a little complex. I have two questions. When requesting official records, does this mean they have to be done by certified mail, or is email acceptable? You can require it, and I think certain statutes say it has to be done. I forget whether the statute says it has to be done in certified mail, but you can certainly create rules indicating it has to be in certified mail. But there are cases of which it's unequivocally clear that the association received the request, and when this was arbitrated in front of the division, the response from the division was, look, even if it says certified mail, if you actually receive the document request via email or some other form, you're obligated to comply with it. And in this case, I think what happened was that the association received an email and told the person, we received your email requesting documents, you need to send it by certified mail. But the answer was it was received. Usually the certified mail is proof that it was actually received by the association, but they didn't provide it. Let me know if that answers your question. When do emails become official records of the association? That is let me flip back one. That is a great question. The answer is emails between board members are not official records. Emails, however, that wind up hitting the association property managers or property management companies' email or server or computer, those do become official records of the association. Let me tell you, I read somewhere recently on some social media platform, when you're dancing, dance as if nobody's watching. When you're emailing, email as if you are going to have to read that email out loud under oath in a deposition or a trial. And we have seen some awfully, awfully bad emails, such as, oh, this is great. I'm glad we finally got this issue. This has been our chance to nail her. I've been waiting a long time to do it. Between statements that you would have never thought would be published with a unit owner complaining to the property manager how they hate another board member and how the board member is slovenly or overweight or grotesque in different fashions or things like that. And now all of a sudden that becomes an official record. And now all of a sudden, you got to produce it. And keep in mind, even if it's not an official record, if you wind up in litigation, your emails, regardless of whether they go to the association computer or not, still remain subject to a subpoena if litigation is filed. Don't send bad emails. Use the telephone. Talk it out. But don't send emails that are going to get yourself in trouble. I remember years ago, I sent an email to my managing partner when I must have been about 4 or 5 years out of school, indicating I was having a problem with one of the associates, and I think this could create a level of liability. And the managing partner sort of called me into his office and said, John, you're absolutely right on this. I appreciate it. I'm glad you brought it to our attention. We already know we have a problem here. This is what we're doing. But he goes to me, he goes, John, what are you doing, though, with an email? If we wind up getting in trouble on this, your email becomes Exhibit 1. There are certain times you may want to actually walk into the office and talk about it. So consider being careful whether when you're using emails. Let me know if that answers your question. Reserves. Reserves are important. You know, nobody loses their home as a result of failing to pay ordinary assessments. People do lose their home on special assessments. So when you have a roof assessment, you know, that's $250,000 spread over everybody, or each unit owner gets hit with a $20,000 seawall special assessment, people can lose their homes on special assessments. And as a result, for those areas of which an association is responsible, the association needs to consider whether it wants to reserve for those expenses or not. In dealing with reserves, and I suggest that this is not as complex as it seems. So if you sit down and you just read this on your own time, I think you'll quickly understand it. If you're an accountant or a bookkeeper, you probably already know it. In dealing with reserves, there's a couple of definitions we use. One is capital expenditures. Purchases or replacement of an asset with a lifespan of more than 1 year, or in addition to an existing asset that extends its life a year, is in fact a capital expenditure. If you make an expenditure on something that's going to extend the life of an asset a year, or for the purchase of an asset that is going to last more than a year, that is a capital expenditure. Deferred maintenance. Deferred maintenance is any type of maintenance or repair that's performed less frequently than annually and results in the maintaining of the useful life of the asset. And a reserve are any funds other than the operating funds which are restricted for deferred maintenance and capital expenditures, including the items required by the condominium statute. So what does that mean? It means ordinary repairs you can't use your reserves for. But if in fact you're dealing with capital expenditures or deferred maintenance, you can use your reserves for those types of expenditures. There are, you know, boards are required to propose a budget, and the budget has to include a fully funded reserves. So there has to be a budget that shows what the budget is with fully funded reserves. And if you want to send a second budget, you can send that shows unit owners can vote to waive the reserves if you don't want to pay them. If you vote to waive the reserves, you have guaranteed one thing, that you will have a special assessment at some point in the future. So if you are not reserving, you are going to ultimately have to pay for deferred maintenance or capital expenditures. You are going to have to do a special assessment. Proposed budgets must include a reserve schedule showing the estimated useful life of the asset and the replacement cost of the asset. My recommendation is when you're determining the life of those items for which you have to reserve, such as parking lots, clubhouses, roofs, exterior of certain buildings, don't sit around the table among yourselves and try to figure out how much the reserve should be. But hire a professional reserve engineer. Associa has ones that they work with. Have them estimate what the reserves are needed for each of the items for which you are reserving. And then usually they will come back every year or 2 years and re-estimate it, meaning did the roof last longer than it was supposed to, or did it not? Do we need to add, you know, to the extent it's going to last longer, can I reduce the amount we have to reserve? To the extent it's wearing faster, do we need to increase it? You know, roofing materials went up. I need to increase the amount we're reserving for it so we make sure we have the money when we need it. Assessments for reserves, to the extent you collect them, need to be in the reserve account within 30 days. Associa knows this. And to the extent they're receiving reserve payments, they know that they need to get that into the reserve account within 30 days. Must you use the most recent professional reserve study when preparing the annual budget? The answer is you don't have to, but you better have a reason why you're not using it. Meaning, if you don't believe it or you think the person is wrong, there's nothing wrong with not accepting it, but you may want to call somebody else out to double check it. You know, good people using the care that ordinary prudent people do, they just don't ignore the advice that they're getting from professionals. So if in fact you don't think this is the proper reserve schedule, you may want to get somebody to get you a different, you know, bring in another reserve specialist to look at it. But to the extent you're relying on professionals, you want to use those. You just don't want to ignore 3 reserve studies that 3 different professionals told you that the roof is going to be $580,000 to fix, and you don't want to raise assessments, so you're just going to keep it at an estimated $100,000. That is not what ordinary people using, or ordinarily prudent person would do. You want to rely on your professionals, and if you don't want to use it or you think the professional is wrong, get the opinion of another professional. Just don't say this guy's a jerk. We're not going to go with this. I did this up north years ago. So 20 years ago, my house on my roof cost this amount of money. This roof is 22 times the size. So let me just multiply it by 22, what I paid on my house 10 years ago. That should be the estimate we're using. That's not the way that you generally should be calculating reserves. Let me know if that answers your question. So there's 2 ways to do reserves. One is a straight line method and one is a pooled method. The straight line method is really sort of simple. What you do in a straight line method is for each of the items for which you reserve, the pool, the roof, the parking lot, the monument signs, the wall around the community, each one of those is a separate account. Each one puts its money in, and you make sure that when the replacement is required, you have enough money to do the replacement. The pooled method puts it all in one account. And then whenever you need the money for any reserve, you can pull it out of the pooled account. You just have one account. By using the pooled method, I believe you save about 22 to 23% on the assessments because you don't need as much money at any given time spread among all of the reserve items for which you are reserving. So you save some money doing it in a pooled method. And as a result, there's a benefit to it, but it's more complicated. Associa has the spreadsheets, the Excel sheets that can calculate that out for you. Over it briefly. The straight line method is really sort of simple. The formula is the anticipated maintenance replacing the / replacement cost less the beginning balance equals the remaining reserves needed, and the remaining reserves needed is then divided by the useful life, and that tells you what you need to fund in any given year. It's a mouthful, but it's pretty simple. If you have a 30-year roof and it's going to cost you $300,000 to fix or to replace, you need to actually you need to raise $10,000 every year for the reserves. And then you take that 10,000, you divide it by all the unit owners, and that gives you what each unit owner pays. So 30-year roof, $300,000 to replace, it's $10,000 a year. Now the math isn't always that simplistic, but that's the formula you'll lose. How much is it going to replace? How long is it going to last? Divide it by the number of years. That's what I need to save every year in the reserves. And then you want to have a reserve specialist come by, once every year or 2 years and make sure that the numbers you're using are actually accurate. The pooled method is substantially more complex, but I'm going to give you a chart that really shows you how it works. You need to take the amount of the contribution for the pooled reserves account, and it can't be less than required to ensure you have enough money at hand at the beginning of the period for which the budget will go to effect. Plus, you have to calculate the annual cash inflows over the remaining estimated life, useful life of all of the assets, and that has to be equal to or greater than the amount that's going out. That means in simplistic terms, you can't have below zero in your pooled account based on the expected cash inflow and cash outflows of any given year. The ending reserve balance must never go below zero, and reserve funding formula shall not include any type of balloon payment. I mean, it's got to be the same every single year. You're not allowed to say, we're going to keep it at, $5,000 a year each year, and then in 5 years, we're going to raise it to $10,000 to make sure we have enough as we get closer to some major expenditures. It has to be the same each year. The reserve funding must be calculated out over the useful remaining life of all assets, which is usually 30 years. And you really need to consult on this stuff, your property manager and your reserve, whatever reserve specialist you are using. If an association decides to have a question, If an association decides to switch to the pooled method, do the pre-collected funds remain in the accounts from the straight line method? The answer to that question is yes, unless you get a vote by the membership to transfer the funds into the pooled account. Does that, and let me know if that answers your question. What you're looking at now is the chart on how pooled accounts are done. So if you look at it, you will see on the left-hand column each of the items for which the association reserving, the estimated lives, the lives remaining, the cost it's going to take to do the replacement, and then the following shows you what the projected cash outflows are in any given year. The trick that you have to have is if you look at the bottom of the column under year 4, you see 0. It goes 6,000, 6,000, 2,000, and then 0. When you're calculating what comes in and what comes out, you can never fall below 0 if you're doing pooled reserves. And this gets a little complicated. You can look at this if you get the PowerPoint, and if you really have questions about it, please feel free to call me. Interest. You know, this used to be a big issue. So for those people that are my age or older, they may remember back in a day and age where you actually got real interest on the amount of money that you had in banks. And if you get interest on if you obtain interest on a reserve account, the interest needs to stay in the reserve account. You're not allowed to use it for something else. In today's world, you may be getting 0.1%, if that, for what you have in your reserves. And you want to be careful putting in anything else other than an FDIC insured account. You are allowed to waive reserves. Owners may vote to waive full funding of reserves. To do that, you need a majority of the quorum of the owners must vote in favor. So whatever you need for a unit owners meeting, you need a majority of a quorum. For condos, you must have include language on the proxy advising that waiving or reducing the reserves may result in a special assessment. And the vote to waive reserves only applies in the year that you do it. So let me take a few minutes and discuss very briefly waiving reserves, and then I'll do the election part somewhat quickly. Waiving reserves is always sort of a big question. Do we do it or do we not? You know, the answer from some is, look, good associations want to make sure that associations have the money, or the association has the money to pay the expenses that may be arising or may be coming. And to do that, we need to have the money at hand. We need to have reserves. That way, we'll never, ever have to ask our unit owners for, or hit our unit owners with a special assessment. If you waive or partially waive reserves, you are guaranteeing you are going to have a special assessment in the future. And a lot of people on fixed incomes or stuff are just not prepared to pay that money, and they would rather pay as you go. It also makes sense to the extent that if you're living in the association each year you're paying your share. So if you live there for 5 years and then you sell it, the new owner doesn't get hit with the special assessment for the full amount, but every unit owner has paid every year that they've been in there their proportional share of the money that's required. And I will tell you that banks are now asking occasionally on estoppel certificates whether the association is maintaining reserves, because even banks know that if associations are not maintaining reserves, some banks do not want to lend money for associations that are not properly reserving because there's a higher level of default. And that are all good arguments not to waive reserves. But the arguments to waive reserves are equally compelling. And those include the following: that I'm an adult, I can manage my money. If you need money from me, just ask me for it. I don't need you to take a paternalistic attitude over me and collect my money for me. I would rather have the use of my money today. I can invest it in the market. I can do other things with it. And when you need the money, let me know. I'll give you a check. But this idea that I need you to watch over to make sure I have enough money to pay debts when they arise here, I really don't need the association's help with this. I have other things that I would like to do with my money. And for those of you who don't want to waive assessments, all you have to do is create a second bank account or have a piggy bank in your bedroom. You know what the full amount of the funding is. Put the money there every month that you'd be paying in associations, and that way when it comes, you'll have it, because we give you every year the engineering reports that tell you what you need to do to reserve funding. So there's no reason you pass a special, there's no reason not to waive or partially waive assessments. There's no right answer to that. These are the questions that each member, each association needs to determine what's best. But I will tell you this, after you go to waiving once, in order to get back on track, it gets doubly or triply expensive every year that that you waived reserves to get back to full funding. So I've always said every once in a while you have an association that's waived reserve 10, 12, 5 years, 10 years, 11 years, and now all of a sudden they have a budget that's passed or at a budget meeting, and then they wind up with a membership meeting to waive the reserves, and for whatever reason a quorum is not present. And when the quorum's not present, you don't have the ability to waive the reserves. So now the budget goes into effect that is now going to require full funding of reserves. Everybody's assessments triple, and then you automatically have a quorum about a month later when you reschedule the meeting to have an additional vote on whether you want to waive reserves or not. But after you go down that path, it's awfully hard to get back on it. Reserves, condos, you must maintain the reserves for the roof, building painting, pavement resurfacing, or any other item whose deferred maintenance or replacement costs are going to be in excess of $10,000. If you're in a condo, it's going to take more than $10,000 on deferred maintenance or capital improvements. You need to have a reserve account for it. Reserves are not required by statute. Association may still reserve for things such as non-required reserve items such as hurricane, storm cleanup, and in such cases, the association can use either method that you want to use, whether straight lined or pooled. But once you've created the reserve expense and it's been voted on by the membership, those funds now become restricted and you can't use them for another purpose without a unit owner vote. You cannot use reserve funds without a unit owner vote for any other purpose other than the reserve account for which they are collected. In a homeowners association, the budget may include a reserve account, but they are not required. If the budget does not include reserves, the HOA is responsible for maintenance of the capital improvements. Financial reports must warn owners that special assessments may result and that the owners could, if they wanted to, establish a reserve. The developer, majority of unit owners in an HOA can establish reserve accounts whenever they want, and if voted to establish, then you fall under the same rules as condos. No commingling, reserves have to be fully funded unless waived, same type of restrictions. This section I'm going to try to do somewhat quickly for me, but if you have questions again, please just feel free to ask them. Then I'm going to take questions at the end of the presentation. Notices of election, condos. The general rule, you need to, within 60 days prior to election, send out a first notice. 14 days, and the first notice basically says, hey, if you're interested in running, let us know. And then you usually submit some bio on yourself indicating why you want to run to the board or have the right to on one side of an 8.5 by 11 sheet of paper. You can almost say anything you want on that. The board is not allowed to look over or make decisions on what you can or cannot advise unit owners. Then days before the election, the association sends the second notice. The first notice informs owners that if they wish to run for board, they must submit their notices of intent in writing not less than 40 days prior to the election. The second notice gives you the ballots and has the envelopes and has the candidate information sheets. And I'm going to go over how this is done in condos. HOAs, generally, you got to give 14 days notice of an election unless your governing documents indicate otherwise. And I will tell you, doing this for the number of years I do it, HOA documents, it just depends on what your documents say on how you conduct an election. A number of homeowners associations now require elections to be conducted the same way as they're required to be conducted in a condominium. To be eligible for the election, you actually can't be delinquent in your payment of assessments. If you are delinquent or owe money to the association, you are not eligible to run for the board. We've actually had the division indicate that if you owe a nickel, you are ineligible to run for the board. A convicted felon is not allowed to run for the board. So if you've been convicted of a felony in the state of Florida, a crime in another state that would be a felony in the state of Florida, or a crime in a foreign country that would be a felony in the state of Florida, you are not allowed to run for the board of directors unless, of course, your civil rights have been restored for at least 5 years. Every election cycle, no matter what, I always seem to get one issue where somebody comes up to me after I say you can't run if you're a convicted felon. Somebody pulls me aside, and then I got to talk to them. And then in an HOA election, usually I announce that so-and-so would like to withdraw their name as a result of family commitments or business commitments or something like that. If you've been convicted of a felony, you cannot run for the board of directors. Condos. Also, anybody who's been suspended or removed by the division, you're not eligible to run for the board of directors. And in condos of more than 10 units, co-owners may not serve on the board at the same time unless they own more than one unit, and there are not enough eligible candidates to fill the vacancies at the time of the election. Condos, you can't serve more than 8 consecutive years unless you're approved by an affirmative vote of 2/3 of the total voting interest, or at the time of the vacancies, there's not enough eligible candidates to fill the seats. So you actually have to, you can't serve more than 8 years. Terms are 1 year unless the bylaws indicate longer. The advantage of having 1-year terms is that if you don't like how somebody's doing something, you can get the entire board out in 1 year. The disadvantage is you could literally have an entire turnover of the board and you lose all of your continuity of knowledge in one election cycle. Officers and directors who are charged with an information indictment relating to forgery of a ballot envelope, voting certificate, theft or embezzlement of funds, destruction or refusal to allow the inspection of copying of records and furtherance of a crime, you are immediately suspended from your position as an officer or director of an association until the matter is resolved. When is a election not required to take place? It's not required to take place in a condo or an HOA if in fact you have more seats than candidates or an equal number of seats of candidates. So if there's 5 seats that are open and you have 4 people running, you don't need to have an election. If there's 5 seats that are open and there's 5 people running, you don't need to have an election. If there are 5 seats open and 6 people are running or more, you need to have an election. Also, HOAs, you need to consult with your lawyer of whether you have to accept nominations from the floor or not. That creates a whole set of problems because if you're trying to get proxies out with names or ballots out, and you have to accept nominations from the floor, all of a sudden those nominated on the floor are not on the proxies that were sent out earlier or on the ballots that are sent out. So you want to be careful, and you want to review that matter both carefully, both with your property manager and your counsel on how to conduct the election. There are 2 types of proxies. There are what is known as limited proxies, and there are general proxies. Limited proxies are proxies of which you give the proxy holder your proxy, and you tell the proxy holder, I want you to vote this way. The proxy holder is not allowed to vote the way they want to vote. They have to vote the way you told them to vote. General proxies are the opposite. I don't really care how you vote. Vote however you want to vote. That's the difference. In condos, you have to use limited proxies to vote to waive reserves, vote to waive financial reporting requirements, vote to amend governing documents, or any other matter in which 718 requires or permits a vote. Condos may not use general proxies to vote unless the vote is for non-substantive changes for items in which limited proxies are allowed. In condos and HOAs, limited or general proxies can usually be used to establish a quorum. Ballots. I'm going to go over this relatively quickly. When you're in a condo election, a number of homeowners are doing the same thing. They're requiring secret elections. So by the time you get the second notice, usually within that package, there is a ballot, a little envelope, and a big envelope. So how do you vote? You take the ballot and you put the X's or the check marks near the people that you want to elect out of the group that are running, the subset that you want to vote. The names appearing on the ballot all need to look the same and are done in alphabetical order, meaning you can't put an asterisk, you can't bold, you can't put a smiley face for the people that the association wants you to vote for the group of people that the nominating committee nominated, or for those board members that are returning. all the names have to generally be the same in an alphabetical order. After you filled out the the ballot, now you take the ballot and you put it in the little envelope. You don't put your name on the ballot. You don't put your address on the ballot. You don't do anything with ballot. You put it in the little envelope. You don't put any markings or information on the little envelope. You then take the little envelope and you put it in the big envelope. And then in the big envelope, you write your name and your unit number, and you either hand deliver it or you mail it to the association. There is electronic voting allowed. In my 30 years or so, even though we have a number of associations that talked about it, I've yet to see one that implements it. Then when it's time for the election, the inspectors of the election actually open or actually look at all of the envelopes, and you compare them to the association's records, and you mark off each ballot, and you make sure you don't have dual ballots and that each ballot is identified with the unit owner. You do that from looking at the large envelope with the name and the address or the unit number. Those items are missing, then you do not count the ballot and you put it to the side. After you have the ballots which you are going to count, and after you've checked everyone in and make sure nobody's voting twice, now you open all of the big envelopes that have the name and the address, and you separate out the little envelopes, and you put the little envelopes into a box or in the middle of the table. And now you separated out the identifying marks that are on the big envelope with the smaller envelope that has no marks. And after that, you then open all the small envelopes, and then you count the ballots. Why do you do it this way? That ensures there's a level of secrecy within voting for members of the board, number one. And it allows you, number two, to tell your neighbor you are going to unequivocally vote for him or her, even though you hate them, and then you vote for somebody else without your neighbor ever being able to know for whom you voted. Condos. You don't need a quorum to have a election in a condo, and a number of HOA boards don't require it either. But you do, but you must have at least 20% of the association voting in order to conduct the election. The rest of this all goes through what I just told you with how you deal with the election itself. Ties or runoffs. If there's a tie or a runoff, the election for the tie or the runoff must be held not less than 20 days or more than 30 days after the date of election which the tie occurred, and within 7 days of the election which the tie vote occurred. The board must mail or personally deliver to the voters the notice of the information of the runoff election. If you want to challenge an election, you actually have to challenge the election within 60 days of the election. If you wait more than 60 days, you are not authorized then to challenge the election. So that prevents you from knowing there's a problem in the election, not really caring about it, then get upset at the board, and then, after 6 months after the election, go back and say, okay, now that you guys are going to do this, we don't like you, I'm going to challenge the election, and then submit your complaint to the division. You got to do it within 60 days. That's the presentation. I'm happy to stay by and answer any questions that anyone that anyone may have. So if you have questions, please just type them in or let me know, and I'm pleased to take any questions that anybody has. Number two, I always offer that if you've attended the course and you have questions, whether you use us or you don't use us, you are still welcome to call me if you have a question. We're not going to research these things for you. We're not going to give opinion letters, but I am more than happy to answer your question over the phone if I know the answer, or let you know generally, what my initial thought is, and that may assist you at a certain level. So if you have questions, please type them in. I'm looking how you unmute everybody. So if somebody knows how to what? Okay, Paul, I can barely hear you.
Okay, how about that? Is that a little bit better?
Yes. Any questions that anybody
Okay.
has or comments? I'm more than happy to take them. Can surplus funds at the end of the fiscal year for the association be rolled over into reserves? And if not, what's the process with the extra funds? You know, nothing says you can't put them in reserves, but if you put them in reserves on extra funds, you can't take them out afterwards without a unit owner vote. Normally at the annual meeting, most attorneys will ask you to take a vote to roll over your funds, and that just makes sure that you're not taxed on any type of rollover. There's a sophisticated method of which, when you're taxed on excess funds in an association or not, most accountants like you to vote to roll over the funds, and then you just roll them over into the next budget. Does that answer your question? And any other questions, please just let me know. And
You got another one.
okay. No, that's a yes. Do you see any difference in election voting, such as by electronic voting during COVID-19? You know, look, electronic voting would be the easiest thing. I'm just, my response to you is I've been doing this now for a number of years. I've yet to see it actually take place. There's a couple of, I think, softwares out there that can allow it. Some are proprietary and you have to pay for it. And we are conducting annual meetings now via video and Zoom. But because the elections in condos take place by written ballots and in the double envelopes, you can do that without actually having everybody in the room together. And for HOAs, I would encourage you, now that we're in August, before election season starts in September or October, to start to look, what do I need to do to make sure that we're able to conduct our meeting and we're going to have a quorum with proxies and everything else that we need to do to vote. Because council can turn around and potentially enact rules or regulations or do the amendments you need to allow the voting to take place by ballots instead of in person. Any other questions?
Yes. Well, William Lynch just submitted one.
This is my first time on the board of directors acting as treasurer. Are there any sources to help me ensure that I cross my T's and dot my I's correctly? You know, you can certainly look generally at what are the duties and responsibilities of the treasurer, and that generally is to make sure the finances are being done right. I always say, as a secretary or treasurer, you have the responsibility to make sure the accounting is done appropriately and done well. You can't delegate the responsibility. You can delegate the duty. So you can have Associa who has a whole accounting department that does this stuff. And you just may want to talk to your property manager, somebody at Associa, to have a good understanding of how they're doing the accounting and you're okay with it. That doesn't mean you need to sign all the checks. That doesn't mean you have to reconcile every bank statement, but it does mean you have to have a sufficient comfort level with how your property management company is doing it. And usually that may involve just a short conversation or a long conversation with your property manager or the backroom office. Any other questions?
Outstanding. Well, Jonathan, yeah, looks like everything, no more questions are coming in, so I want to give you a chance to breathe a little bit, maybe get a drink. So really do truly appreciate the opportunity to have you do this seminar, and you've given us a lot of information. For those of you still on the call, I will be emailing you the PowerPoint slides. It'll be in a PDF. It'll be coming out. Working with Jonathan will ensure that everybody on the call will get their certificates in a timely manner. So we'll take care of those things. From an Associa Gulf Coast perspective, if you're a current client, we certainly hope that you continue to be happy. If not, please let me know. For those of you who aren't an Associa client and you have any questions or concerns about association management, I'm more than happy to help you out, even if you don't use us. Just like Jonathan said, we are resources for you. There's a lot of stuff going on in the association management world. It changes every day and certainly every year, and we're here to help. Naturally, we want to work with you, but worst case scenario, you have a question, reach out, let us be a resource. Jonathan, again, thank you so much for your time today. The wealth of knowledge and much continued success with you and your career. For those board members that are still on the call, thank you very much for your time. And again, I will be in touch with you both for your certificate and for that email with the PDF of the PowerPoint slides. I don't see any more questions coming in. Again, thank you all very much for your time. And if there's anything we can do, you'll have both my contact information and Jonathan's contact information sent to you via email here shortly. Thank you very much, everybody. We really appreciate your time.
Thank you, guys.